I will quickly introduce our speakers for the session today, but Frank needs to get off at 11 o'clock, so I'm going to take two speakers and then we'll break for some questions and then come through. We have 5 speakers this morning. Dr. Frank Hofmeister from DG Trade is on my left. Dr. Laurent Bartel, the next one to the left, is from Cambridge University. And from General Electric, Fabien Delcroix, third one to the left. And then to my right is Dr. Reinhard Quick and Dr. Dalindi Abo Shabalala, have I pronounced that correctly, from Maastricht University. Sorry, Dr. Quick is from the German Chemical Association. And immediately to my right is my fellow MEP, Michael Thurrow. So welcome all of you today, and I'm going to give each of the speakers 15 minutes, and then after the first 2 speakers, we'll open the floor to some discussion, and then we'll take the next 3 speakers. So, first speaker, Dr. Frank Hofmeister. Dr. Frank is Deputy Head of the Cabinet of Trade Commissioner de Gucht. His work is with the WTO and dispute settlements, G20, trade and environment, agriculture and geographical indications, trade defence instruments, OECD and public procurement. I'm not quite sure what he does in his lunchtime, but that seems a big portfolio to me. So thank you very much. Over to you.
Yes, thanks, Catherine, and also Michael, for this kind invitation. And indeed, it's a topic which merits discussion and an exchange, an open exchange of views. And I would just simply try to sum up a little bit the Commission position on this issue, and then in the Q&A session we can then go into a deeper exchange. So first, let's recall that the Treaty of Lisbon has made a fundamental point, namely that trade policy should not only foster trade objectives, of course that's our primary objectives, but trade policy should also contribute to the objectives of the EU's entire external action. Article 207, 208 of the Treaty on the Functioning of the Union, that's a new element, and that means that there is a certain constitutional duty to ensure consistency of EU external relations. Trade policy, therefore, is not an isolated island, but on the other hand, it's also clear that for environmental and social policy as such, we have also the domestic policies and their external dimension. It is not so that trade policy all of a sudden turns into social or environmental policy. It should contribute to achieving those objectives. And as usual, a treaty does not say how. So the fundamental principle is there, but how can you contribute to achieving those objectives is left in the hands of the institutions, in particular, of course, the Council, the Commission and the Parliament. And in that regard, it's very important that Parliament voted a resolution in November last year expressing very clearly its views, and the Commission is called upon to take these into account when defining our own practice. Second point is what do we do multilaterally? So in a situation where we are sitting with all other trading partners on the same table, in particularly in the WTO. And here you know that trade and environment in particular has been a topic of the Doha round. At the request of the EU, we have very much worked to get it into the round. And a particular point was to try to get specific negotiations on environmental goods and services with the aim to liberalize trade on those. The idea being that environmental goods and services do promote also public goods and therefore should be able to benefit from further liberalization than other goods. That was a clear, long-standing EU objective. Unfortunately, we are not very far on that. It has to be admitted, but the EU stands behind it. On the social side, situation is more complicated because here WTO members are themselves more reluctant. You may know that in the GATT there is some sort of a reference, namely in the article to justify trade restrictions, there is a reference to prison labor. Article 20C of the GATT says members can restrict trade when it is made out of prison labor. That is an old provision from 47, goes even back to an older statute in the United States, but that's it. It doesn't talk about social rights, it doesn't talk about others, simply restricted to prison labor, and it's a long-standing discussion on the WTO whether that should not be expanded to include other core social rights, but there is no consensus. So people disagree about this question, and therefore it's also quite difficult to establish specific bodies to discuss it. For example, a committee on trade and decent work has not yet been agreed by consensus of the members. When we come to dispute settlement, environment and social standards may play a role as an additional source for a specific dispute, and we could also ask specific experts to put their views into a case. There is a possibility in the dispute settlement understanding, and the EU would be certainly in favor of that. So multilaterally, in sum, we are in favor of getting the topic across in a measured way, but in particular on the social side it's quite difficult because clearly a number of partners conceive this agenda as protectionist. One has to be very clear, because if you push too hard social rights, people say, aha, you want to impose certain wages on us and thereby you take away our economic advantages and so on. So this is not to the liking of many WTO members, and one has to be quite careful on that front. What do we do bilaterally? Bilaterally, there is a recent practice to include so-called sustainable development chapters into trade agreements, and I know that Kathy is a big expert on that. It is clear that you cannot come up with the same formulation with all countries, because different countries have different views on it. We have South Korea, Peru, Colombia and India currently negotiating, and in an agreement the other side has to consent to the formulation of a clause. Therefore, we have different formulations right now. But we believe it that the principle as such to have sustainable development chapters is unnegotiable, and we try to get the clauses into those broad agreements. A small caveat, when I talk about trade agreements, I mean fully fledged trade agreements. We sometimes have sectoral trade agreements limited to, let's say, mutual recognition of a certain standard or to a certain product, steel or what have you, then probably it doesn't make much sense. But if we have a fully fledged trade agreement, a free trade agreement, for example, then sustainable development has its right place. What are those clauses doing? They refer to international standards, in the social area to ILO conventions, in the environmental area to certain multilateral environmental agreements, and try to make sure that the partner country of the EU also respects those international norms in its domestic policy. So it's really something which says you have to do internally, certain practices, you have to follow certain norms, and that is quite something, because in trade normally you talk about the exchange of goods, and here you tell another partner what to do in domestic regulation. How are those clauses implemented? Well, we have a monitoring system which allows the dialogue on those matters, and importantly on our side, in order to get civil society on board, the Korea example is clear on that, we want to create domestic advisory groups with the social partners included. So trade unions, NGOs and so on can be part of the EU's internal domestic expertise, which are then going into the monitoring system with a third country. What those clauses are not doing, and let me be very clear about it, is to justify trade sanctions. Because we believe, and that's the view shared also by Council, that on those matters it is better to induce progress by implementation, monitoring, and let's say positive attitude, rather than to threaten sanctions. That's a policy choice, and I wanted to be clear that this is the current situation, and we can certainly discuss about it. And that brings me, ladies and gentlemen, to the end of my 15 minutes. So I'm not going to talk about unilateral measures, because the topic here is trade agreements. But if you wish, I can also mention GSP in the discussion. So in the conclusion, current position of the European Commission is that trade policy can indeed promote social and environmental standards, but it has to be following a number of principles. And let me reiterate what are those in our view. Coherence, there must be coherence with the foreign policy objectives, but of course it cannot be one size fits all. If a country, a partner does not accept the standard formulation, one has to be able to flexible enough to negotiate formulations which are then fitting a specific partner. It has to be credible, meaning that it's not just an ad hoc policy, but it is a systemic, a strategic policy. And I'm very grateful also for the Parliament to in the resolution to have made this point clear. It should be transparent. That's why we try to include civil society in our domestic, let's say, way how to monitor those. And of course, it should be effective, but that's something where I cannot speculate. It's a rather new practice, and therefore, of course, I would be very much welcoming your views on the matters. Thank you very much for your attention.
Ja, vielen Dank an
Thank you very much, Frank Hofmeister. I would like to point out that we have a meeting today. So there's a number of questions that came up, which we will be able to discuss later on. There was the big discussion about the social and environmental standards. To what extent could they be integrated in trade agreements, and questions like Colombia, which wants other formulations in South Korea. And I wonder how we can go into more depth into this discussion. Now, I would like to welcome Dr. Lauren Bartels as the next speaker. Lord Bartels is a professor at Cambridge University. He is a member of the International Association for the International Law Association and the International Trade Law Committee, and is also a member of the Executive Council. A warm welcome to Dr. Lauren Bartels.
So, sehr vielen Dank. Schön hier zu sein.
Thank you very much. It's nice to be here.
So, I'm going to follow on from Frank, actually, fairly neatly, I think. And what I thought I would do is outline for you the recent practice of the EU in its bilateral trade agreements by referring you to the recently released initial text of the agreement with Peru and Colombia. And then I'm going to make some comments on this and compare it to some other practice around the world. So, first slide, please. Okay, so I thought I might just start with a very quick reminder that trade and social values can go hand in hand. And if the one point, I mean, this will be familiar to everybody, just a few points why trade is good for social values. But the last point is also important, which is that all the benefits under a trade agreement can also be removed via trade sanctions, if that's what you want to do. And as we'll see, in some cases at least, that is what the EU wants to do some of the time, in principle. Next slide, please. So these are what we're more concerned with regulation. Of course, the positive effects don't require any additional regulation because that's built into the agreement. But there are some negative effects, potential negative effects, I should say. These will also be familiar to you. Of course, trade does displace workers. If it didn't, you probably wouldn't bother with the agreement. Sometimes that can put people beneath the level of human rights protection. And in particular, it's important to note that when women are disproportionately affected, this raises special problems under human rights law, and that can happen in certain countries. I think there's no need, given the limited time, to run through this. Just a quick flick through that will remind you, if you need reminding, of these issues. But the main point there is in the last sentence, which is that all of this justifies, it doesn't require, of course, regulation to accompany trade liberalisation, but you do have a coherent justification for it. Next slide, please. So now I'm going to talk about two main categories of regulation in the EU's practice, human rights clauses and then more recent practice on social clauses. I should say it's not entirely a coincidence, but it's great that I'm sitting next to Frank here because he wrote the first book on human rights clauses and I think I wrote the second one. So there's a risk of turning this into a very long discussion, but I won't. They haven't actually changed an awful lot since those days, and basically it consists of an essential elements clause, which says respect for human rights is an essential element of the agreement. Then there's a sanctions clause, which is actually somewhat badly taken from old safeguards clauses, somewhat inappropriately, but this is the form of the sanctions clause. And you can have elaborations on this, and in the Cotonou Agreement you have the most elaborate of these. Now, the important point now is that human rights includes labour rights. And that's actually expressly said in the Cotonou Agreement. And of course, some environmental rights can also be categorised as human rights. So this is by no means simply limited to military coups, even though that is generally how the Human Rights Clause is activated. Next slide, please. A disappearing policy. Yes, it's very sad for those who like the Human Rights Clause, but it seems to be disappearing a little bit. Yes, there is a human rights clause in the Colombia-Peru agreement, which is one of the good things about it, but there are missing human rights clauses in the Korea agreement, the CARIFORUM agreement. Now, of course, I shouldn't know this, but there is a leaked text of the Canada agreement. There doesn't seem to be a human rights clause in that, and there's no text, of course, on the India agreement, but one can only speculate, but speculations seem to be that there's unlikely to be a human rights clause there. Why? Well, sometimes you hear the argument that there's an existing clause in an existing agreement. I think this is somewhat plausible when you do have an existing agreement and the existing agreement provides for appropriate measures which would allow you to suspend another agreement. Mind you, that contradicts the Commission's old policy, which was to say that that couldn't happen. But this seems to be a more convenient argument these days. But it certainly doesn't work when there's no appropriate measures, when all you've got is a very basic type of human rights clause, which you have, for instance, in the India agreement, which just, and the European Court of Justice said this in a case, simply permits that agreement to be suspended. So, basically, the free trade agreement with India, if it doesn't include a human rights clause, will not be subject to a human rights clause. I mean, that's just a legal analysis, my legal analysis anyway. And with Canada, you've got a more serious problem because there's no pre-existing agreement at all. In other words, practice is variable. We have human rights clauses persisting in some agreements. We have them disappearing in others, and that's important from the European Parliament's point of view because the European Parliament has said in resolution after resolution that we need to make sure that there are human rights clauses in these agreements. Next slide, please. Now, the labour and environment clauses, sometimes this is known as Sustainable Development Chapter. The old policy was cooperation is good. And next slide, please. The new approach is that cooperation is good, but binding standards are better. And this is interestingly, a sort of copy and paste from the Western Hemisphere model, which originates in NAFTA and evolved and spread to South America, and it seems now to have moved its way eastwards. These clauses, as we will see, are all originally NAFTA-based text, with variations taking into account some let's say, EU quirks and also some post-NAFTA practice. But that's the intellectual and drafting origins of these clauses, and it basically involves minimum standards, which are binding, monitoring, involvement of civil society. In the case of the EU, separate enforcement mechanism with weak remedies, but as we'll see, that doesn't have to be like that. And of course, as Frank said, this is a policy choice. Next slide, please. So I thought I'd just run you through some of these clauses. I mean, it's a lot to read. So I'll just point you out the important bits. Second last line, each party shall strive to ensure that its relevant laws and policies provide for and encourage high levels of environmental and labour protection. Now, you might think that this is what's called a best endeavours clause, but best endeavours clause, and it is, but best endeavours clauses can be violated. No, I mean, if you abolished all of your environmental laws, you'd be in violation of the clause. It is possible to violate a clause written in this way, even if it's not easy to do. So this is one clause we have. Next slide, please. Then we have another set of clauses. This is the labour clause, which says, this is all from the Colombia-Peru agreement, by the way. And this is harder. Each party commits to the promotion and effective implementation. In other words, both parties have to implement core ILO conventions, and they're listed. I didn't put the list of the core conventions on the slide. So this is now a reference to an external fixed standard. Although what we don't have is any reference to ILO monitoring of violations, but you could say that might be unnecessary. When it comes to monitoring, that would be taken into account in any case. So here we have a fairly hard binding standard, and one point to note, it doesn't just relate to trade and investment under the agreement. It's general. You just need to do this. There's no need to link it to what the agreement does. Next slide, please. Okay, so now we have a couple of caveats, one for each side. Well, of course, it could be for both sides, I suppose. First, a non-protectionism caveat. To stop protectionism, how high can you go? How high can your standards go? Well, with labour standards, you can't do this to the extent that it harms trade with the other party, protectionism. You don't have this for environmental measures because this is permitted usually and subject to certain conditions under the agreement itself via the general exception. So you can always regulate to maintain a high level of environmental protection, and there are already some conditions attached to that right which prevent protectionism. So the reason that you have this for labour is because you don't have an equivalent for labour. For the reason, as Frank mentioned, it's not particularly common to find this type of thing in the exceptions in the WTO, and therefore also not in bilateral agreements, except of course for this prison labour clause. Okay, next slide please. And then we have the opposite, how low can you go? Well, you're not allowed to encourage trade, race to the bottom, in other words, by failing to, by not having regulations or by failing to enforce the regulations that you have. And this conceptually links to that first standard provision, the best endeavours provision, but it's written in a slightly different way. So basically what we've got at this point is some minimum standards with references to the outside, and a certain degree of control at the upper end and also at the lower end. I should mention, I didn't want to put it on the slide, but the reference to the ILO with labour is paralleled by references to multilateral environmental agreements, the standard ones, like there's Kyoto, there's Montreal, there's Basel, Stockholm, Rotterdam, and so on. Next slide, please. So, what else could there be? I mean, what's there already, I should say, is pretty standard. It's best practice. You know, if you look around the world, a lot of FTAs do similar things these days, all, of course, derived from this original NAFTA model, but involving non-American parties as well. What else could you have if you wanted? I'm not saying this is necessarily a good idea. I just thought I'd give you some make trouble for Frank, basically, by suggesting that you might want to make reference to OECD principles on multinational enterprises, a type of corporate social responsibility. In other words, starting to regulate the companies. It's actually a very interesting set of principles which talks, among other things, about companies' responsibilities to make sure that their suppliers in third countries comply with human rights and labour standards and so on. Or what about something that business might like, the Anti-Bribery Convention? And there are obviously other things. So this is just to say, once you start introducing one standard which relates to trade, you can also introduce others. I mean, you might want to put in the compliance with the New York Convention on Enforcement of Arbitral Awards. Why not? The Americans do this. I think it's also in the GSP program, and I think it might even be in the EU GSP program. I can never remember this list, it's getting so long. Okay, next slide, please. What about monitoring? Well, this comes in a number of different dimensions. So first of all, the parties undertake to do this at home. That's pretty weak. And of course, you've got that old international law carve out there through its respective domestic and participative processes, which is always what you put in an agreement when you want to retain control over what's going on. Then you also have the parties jointly. So there's an office, that's when one side wants to talk to the other side about a problem. But there in paragraph 2, there's a subcommittee established in the Peru Agreement, and this is becoming a good practice. The CARIFORUM Agreement has something somewhat similar for civil society. And basically it's a sort of talking shop, as we'll see, but that's definitely a good thing. Next slide, please. Then we have civil society at home. So again, we've got references to domestic law, and you should talk to your people back at home. And then we bring it all together. Next slide, please. With the subcommittee under the agreement, talking to the newly constituted and enlightened and engaged civil society at home. So it all forms a nice compact, and this is supposed to happen once a year. So, next slide, please. What do we think about all of this? Well, what's missing, first of all? Parliament's missing in the Peru and Colombia agreement. But it is there in the CARIFORUM Agreement, so we have some variable practice. And what can we make of the role of civil society? Well, internationally speaking, it's pretty weak, actually. Where you get this much more strongly is in the US practice, Canadian practice, and so on, where you have citizen submissions. And under NAFTA, we've got about 50 each for labour and environment, where you as the citizen or the NGO or whatever can make a complaint about what's going on under the respective social chapters. I also made a reference here to the GSP. Now, this isn't formally in the GSP, but in practice, civil society brings issues to the attention of the member states or the Commission, and interestingly, both of them have an obligation to act on this, and it ends up with the GSP committee. Now, what about the subcommittee? It's got a pretty weak role at the moment, doesn't do a great deal, and one idea, if one wanted to strengthen this, might be, and this is borrowing a little bit from EU law, to require the Trade Committee, which is the name in this agreement, it's normally called a joint committee for the main committee, require that main committee to give a reasoned opinion on what's going on, or maybe require the parties to give a reasoned opinion, or something. That's just an idea. Next slide, please. So the Peru Agreement also has a human rights clause, and here I'd show you what it actually looks like. So that's the what's sometimes called a basis clause or an essential elements clause. So the last sentence is important. Respect for these principles constitutes an essential element of the agreement. So very old-fashioned language. Next slide, please. And then what do we do about this? Well, the enforcement is actually quite strong because, as you can see, in Article 8, Paragraph 2, you go to dispute settlement. And then in Paragraph 3, you can also impose appropriate measures, which is anything you like, really, consistent with international law, and basically was originally designed to be suspension of financial aid for the ACP, but also, of course, includes suspension of other benefits under the agreement, like trade. So, labour is not ignored in that. Labour is in fact included in that, so long as you can describe it as human rights. Now, what about disputes? I just put that there to contrast with the dispute system. If you could just flick to the next slide, please. For labour and environment in the Peru Agreement, and this is pretty standard, again, as Frank said, it's a choice. Well, what happens if there's a problem, and this is party-generated problems, right? Civil society is out of this. You have a group of experts which deals with this in a semi-arbitral way, and you can see what happens there. When the experts have done what they do, and they tell the party shall inform the subcommittee of its intentions as regards the recommendations of the group of experts, including the presentation of an action plan, and the subcommittee will then monitor the implementation of the measures, and that's kind of it, really. And you can't go to dispute settlement about any of this, right? So it's just in its own slightly unenforced world. And that's there because sometimes you can make a mistake. You can set up a wonderful carved out dispute settlement mechanism, but you can forget to say that that's not subject to dispute settlement, which means that the whole process has judicial review on top of it. But that mistake isn't made here. It's a proper carve out, on my reading anyway. So then we have the final couple of slides. What do we think of this? Well, we have no dispute settlement and no real control over labour and environment. But we do have this for human rights in the Peru and Colombia agreement, but not in a whole lot of others, either because they don't have a human rights clause, or there are also cases where there's a human rights clause, but it's carved out from dispute settlement. What would some alternatives be? This is to do with, well, firstly, you apply dispute settlement, but really, what remedies would you apply if you wanted? Two main categories, which is what you do under the human rights clause, actually. Number one, you suspend obligations, trade, whatever you like. And that's done in the US agreements. I mean, this isn't made up, this isn't idealistic. This is there. Not all of them, of course, but this is recent US practice. And it's done in GSP, and it's done in GSP in the EU GSP as well. Now, of course, you can say, agreements are different, they're negotiated, the other side has to sign on, and all of that is true. I mean, I don't want to pretend that the EU, if it wanted to do this, could always do this, by no means. I'm just comparing this with the corresponding practice in other agreements, where countries do sign up to this. And the second thing you can do is you can impose fines. Now, these aren't, huge fines that cripple a country. They're not actually particularly, to use the language of countermeasures, an inducement to comply with obligations. In fact, it's more like cooperation. So the fines, as they exist, and this is in US practice, Canadian practice, and so on, as you can see, I've summarised it there, you spend it on all the things that have gone wrong. So it's a sort of enforced financial cooperation, I guess you could see it as, rather than a real sanction. And the fines are collected by suspending concessions. So there's a link there with the first point. Okay, and then the final slide, please. And this is just a list of ideas, suggestions as to what one might do if one were interested in ensuring high standards. And of course, there is a big debate about how much you want to do this. I'm not taking a position. But if this were the policy choice, these are some of the things that could be done in summary. So one thing is to watch out for this disappearing human rights clause and be somewhat skeptical of arguments that you don't need one in a trade agreement because an existing human rights clause covers it. I mean, I can point you to pages in the second book on the human rights clause, and I don't remember, but I wouldn't want to prejudice DG Trade, but I could probably point you to pages in the first of these books which would point this out. Second point, you could say something about CSR in terms of the standards. Third point, civil society is pretty weak in the Peru Agreement. It's a lot better, a lot stronger in the CARIFORUM agreement, but it's nowhere near as strong as in the practice of the US and so on. Now, again, I'm not saying how successful that has been. In fact, it hasn't really amounted to an awful lot in almost all cases, but it's there, and it says something. And then, of course, the lawyer's favorite, more remedies. So this is just a sort of shopping list if one wanted to beef up the agreement, and of course, if one had a willing partner. Thank you very much.
Well, thank you very much. Much there to discuss, and I think we're going to throw the floor open now to questions. My first thoughts there, as ever, and it's something that I've challenged in committee, is the enforcement. Whatever we write into these agreements has to be enforceable, otherwise it's a waste of time writing them. And I think your last slide there and the last few, I think the last one perhaps was missing the role of Parliament, because as I understand it is Council that makes final decision, but I think there is some concern about what Parliament does. And your idea of fines, I'm just think back to what happened when GSP Plus and Sri Lanka, we were getting hard with them, and we were told where to go with our agreement, and I suspect that fines would go the same way. So right, let's open the floor to questions. I'm sure we've got some. Michael, did you want to lead off?
Yeah, thank you very much, Catherine. We discussed as members in the International Trade Committee in the European Parliament especially one question. We would like to push social and environmental standards, and we would like to include the civil society, but we don't want to overload the free trade agreements. It should be handleable. So my question to Frank Hofmeister is, in the South Korean agreement, and I was shadow rapporteur for our group, we have included the civil society groups. I think you just mentioned that. If we look at the draft of the Colombian, it is not included. Can you just describe what are the reasons for these differences, and why can't we include a kind of minimum standard inclusion of civil society groups?
Thank you, Michael. Let's take another couple of questions. Has anybody got anything? Just raise your hands. No? Yes, there's one down here.
Thank you very much, Gregor Thury from FIDH, the International Federation for Human Rights. First of all, many thanks for those two very interesting presentations. I have four, but very concrete questions. The first is on the human rights impact assessment of EU trade agreements. This is one of the key recommendations of the EP November 2010 report. The EU member states and the EU as a whole has an obligation to make sure that none of these international agreements have adverse impacts on human rights. At this stage, our assessment is that the EU cannot demonstrate that the international trade agreements have or not positive or negative impact. So what is foreseen? How does the European Commission plan to react to this recommendation of the EP? The second question is on the forced labor, because Mr. Hofmeister made a very interesting reference to the GATT provisions on the prison labor, which justifies restriction on forced labor. So my question is, what would prevent the European Union to adopt a ban on the import of products made with the use of forced labor, for example, made in the Chinese detention center, the Laogai? That's an issue that was brought to the attention of the Commission by FIDH and other organizations, and there is, if I'm not wrong, a current complaint on the Laogai under the GSP Plus mechanism. The third concrete question is on the human rights clauses. Mr. Hofmeister, you made also a very interesting reference to the new provisions of the Treaty of Lisbon and the need for consistency. And in the presentation of Mr. Bartels, it was clearly shown that there is a huge diversity of situations about the human rights clauses in the free trade agreements. Some have a human rights clause, some will not have human rights clauses, and some have concrete dispute mechanisms, some don't have. So does the European Commission plan to work for an harmonization and more consistency about those human rights clauses? And the last question is about the GSP. With the development of FTAs, often offering the same benefits as GSP Plus, but without any human rights conditions. My question is, how can you guarantee that these FTAs will not render the GSP Plus obsolete? Thank you very much, and sorry for if I was too long.
Thank you, Gregoire. Just in case you didn't catch Gregoire's name, is Gregoire Thierry, who is the permanent representative to the EU from the International Federation of Human Rights. So there were a lot of questions there, Gregoire. So I think rather than open the floor any further, let's our speakers come back on those. Did you want to go first, Frank? Thank you.
Yes, thanks a lot for giving me the opportunity to clarify a number of points. Michael, you've asked about the reasons of different treatment of civil society groups. I think it is important to understand that a third country partner is much more willing to accept sustainable development chapters if it is not coupled with a very tough implementation sanction system. And that's number one. Huh? We have experience that in negotiations, if you say, we want to address the issue, the first question is, why do you need it in trade? It has nothing to do with trade. So the Commission has a very hard time to explain why social and environmental standards form part of a trade agreement. And in order to get over this threshold, we have to say yes, because we want to talk. We want to monitor, we want to see, we want to help. In that kind of situation, it is of course very important how the third country reacts and whether it has at home trust to its own civil society. And unfortunately, in the two cases you mentioned, there was difference in that particular point. And I don't have to explain further. But what we can always do, and I think there you have a point in the European Parliament, is of course at home. The EU at home can say, in order on our side that we monitor the situation there, we can design or systems where civil societies have its legitimate role to play. And that is something which is then a question of the side legislation when you ratify a treaty and when you have gone through that in Korea, safeguards and so on. Yeah? You can make a number of things which, how to say, are directed to the EU internal process. But to get it as a clause into an international agreement, you need the consent of the other side. And as I said, the problems are considerable. Just to make one point on India, still the Indian position is sustainable development chapter has no right place. So you have already to go to overcome the first threshold. It's not as easy, and I'm very grateful to Lauren to have made the point. You can put certain things in your GSP. Unilateral trade concessions. That's what the EU legislator decides, no problem. But in an international agreement, you sit with the other side and you need to have the trust with the partner that this is something useful for both sides. That's not just EU imposing certain issues on the other side. I think that needs to be stressed. Now, on the four very detailed questions from our friend from the Fédération Droits de l'Homme, impact assessment. The Commission has publicly stated that for major free trade agreements we will make an impact assessment on economic and social impact of those, and I don't have to stress that in some issues the economic impact is what drives a lot of civil society. Let's just say agriculture and Mercosur. What will be the impact of Irish farmers? Yeah, and of course in these kind of assessments human rights can be included, but there will be separate human rights impact assessment. I mean, we will make one impact assessment on major trade agreements, and then we'll see whether there are specific issues involved.
What is major? What's the criteria for major?
Well, I think the major, it's a free trade agreement, for example. Okay. A free trade agreement which tries, as you know, to be ambitious, where we have a lot of of liberalization, including sectors, services, public procurement, GIs, what have you. Huh? On the question on forced labor import ban, strictly speaking, this is not an issue for an agreement. You're asking whether we should impose unilateral legislation to import products. First of all, there is a international framework which we have to watch out. That's the GATT. And the GATT says if you want to restrict trade towards third countries, you need to have a specific reason to justify it. I told you that in the GATT it's old-fashioned, Article 20C, that's not mentioned. We could invoke probably another justification, which is public morals, 20A, but public morals has not been tested in court. Now, we need to be very clear about it. That's the first question. Second question is, how can you monitor that? How do you know which products come from forced labor? It's not written on the face of a product. And you need to have an implementing system that a customs official at the border can say, and this is something which falls under regulation, the other product not. That's why normally in international trade, the processing of a product is not included, but on this particular point you can of course say that's ethical minimum standards, but I just wanted to make this point, and need to be very careful on this, and the discussions are ongoing. On the consistency on human rights clauses, I think the Commission is in favor of consistency, and the Council has very clearly said in 2009 the agreements need to have political clauses, all agreements of the EU, including a human rights clause. So it's the starting point of every negotiations. We put the human rights clause on the table. And just to tell on Korea, Laurent, there is a political agreement with Korea with a human rights clause, and the free trade agreement in the beginning makes an explicit link. So I not fully share your assessment that we could not have a situation to use a human rights clause also for the trade agreement. It's in the political agreement, and there is a specific link. But it's true, sometimes this is not fully possible, and then again, we as Europeans, we try to bring this forward. We have also an institutional mandate to do that, but what comes out of negotiations is not always 100% what we want. And final question, relationship GSP, free trade agreements. I think that's now before the Parliament. We've made our GSP proposal, and I think now for the Parliament and the Council to look at it, how the conditions on GSP Plus and the relations to free trade agreements will work out. And you will accept that I don't want to prejudge those discussions on the matter. Thank you very much.
Thank you, Frank. Laurent, you wanted to come back on those questions?
No, I think they were mainly directed to Frank. I'm happy with his answers.
Okay. Right, any other questions from the floor? I'm looking around, I can't believe... Yes, this lady over here.
Hello, I'm Michaela from P Europe. I would have a more general question, because you referred multiple times to the role of the European Parliament in this, and obviously that role has been strengthened through the Lisbon Treaty. So I would just be interested in the more detailed implications, or like the implementation of those strengthened roles. We've seen that with the South Korea trade agreement already, but I would just like to have your view on that and how you see that evolving over time. Thank you.
Thank you. Any other questions? No? Michael, was that direct at you, Michael, or?
It's very easy to answer. Therefore, we make this hearing to get a closer insight in what can be the instruments, because as it was mentioned, that in resolutions of the European Parliament, it was always strengthened that there should be a stronger implementation of environmental and social standards. And we just wanted to get more insight now of the technical side, how that can be achieved. And therefore we are sitting here. This is the common goal of Catherine and me, and we want to give an input in the discussion of the Liberal Group. And I think with the Lisbon Treaty, that will be the huge task and challenge for the future.
Yeah, if I could just add to that, I see. I mean, it's been raised the role of civil society here, And when we talk about civil society, mostly they lobby us as their parliamentarians, as we are their representatives in the European Union. That's what we're here to represent the citizens. So it seems to me that we should be playing that role. Where it's weak in the agreements that the civil society has a role, that's where we should be picking up. My concern always is the enforcement. We can write whatever we write in agreements. If they go wrong, who is going to take the decision once the companies have, each member state has got companies invested in these third countries and busy doing business? It's not going to be easy for representatives of those governments to take the decisions. It may be easier for the Parliament to stand up and say, look, it's not going well. In the Colombia Free Trade Agreement, we've gone down that route in the face of huge opposition from civil society, who say that what's going on in Colombia is still not good enough to even have GSP plus, and yet we've moved on down the road to working towards the agreement, almost at signing stage. My other concern is the environment, as you heard, and what we've just heard about negotiations, opening up negotiations, that, well, you know, we want an agreement, so we'll put that to one side. I think if you ask most of civil society and the community, is the environment important? They would say, yes, it is. It's as important as everything else, because without the environment, we don't have anything to trade with. So that's my thoughts. I think maybe, did you have anything else to add on those? No? Okay, let's move on then to our next speakers, next set of speakers. We'll take 3, I think, now, and then we'll go back to questions after that. And they each, I'll just remind gentlemen, you have 15 minutes each. We'll go to Fabian Delcroix from General Electric. Now, Fabian joined General Electric as a Director for European Government and Relations and Policy. In this role, he is responsible for leading, coordinating and driving execution of General Electric's government relations and policy initiatives and strategies in Europe, with a particular focus on the EU. Fabian is working closely with with General Electric business and corporate GR teams on a broad range of European legislative and policy issues. So thank you very much, Fabian.
Thank you very much, Catherine. Thank you very much, Michael, for inviting someone who's not a doctor in law, I'm afraid to say, and I'm quite impressed to be here with these impressive 4 panelists. I'm not a doctor in law, but I have a contribution to your answer to the last questions on does environment matter in trade agreements? And to add to your answer, from a business viewpoint, it's a big yes. And we not only need environmental standards, but also need free trade for environmental technologies. And if I may, the main message that I want to pass today to you is basically that we are now facing enormous challenges as far as green technology, renewable energy technologies are concerned. We are in need of billions of investment in the world, and one of the most important contributions that free trade agreement, multilateral, bilateral, WTO, whatever, can contribute to is basically free the market and level the playing field. So having said that, I want to go through basically 3 topics. Today, the first one is the less important, why I'm here and why General Electric. The second one is which are the barriers that we are confronted with around the world, be that trade barrier, non-trade barriers. And then the third cluster of issues I want to talk to is how to address them concretely and what your contribution from European Parliament can be to help us increase green growth in Europe and over the world. So if we can move to the first slide, and maybe the slide after, yes. Why General Electric? Why I'm here very quickly. We are in Europe for over 100 years. We have more than 90,000 employees. You see lots of points here of every colors. It turns out that we are not in Corsica and not in Sardinia, and not in Sicily, I'm afraid, but we are in most of the 27 EU countries, as you can see. So much for the free publicity. We can move to the next slide. We are here in Europe, and we are world leader in green technology and sustainable growth. We have invested $5 billion US dollars so far in these technologies. And the interesting point here, it's not about investment for free, it's about business. And we are creating green jobs. We have generated 18 billion revenue out of our green product matrix in 2009 with an investment of 1.5. So this is a clear answer to those who still doubt that there is no market for green technologies. But to come back to the issue today, we are on a very specific market worldwide. Why? Because we are not only confronted with private kind of competitors, but also are competing on government-driven markets. Governments being very much present as customers, as producers, and as regulators when you talk about renewable energy. And the last comment I want to make here is that we are here also talking on behalf of other very important European actors. And I must acknowledge the presence of Jens from Vestas here today with us. And we are also pushing this green tech, free trade green tech agenda together with European companies such as Alstom, for example, or Philips. Let's move to the next slide, where I want to concentrate on which are the barriers that we are confronted with before moving to how to address them. So the barriers, no surprise, governments being very much involved, and governments around the world having identified green technologies as a strategic issue. What do governments do? They protect themselves, especially when they are producers of these very green technologies, trying to favor their national champion. How do you protect yourself? You raise tariffs. And here you can see the level of tariffs, applied tariff around the world for very emblematic renewable energy products, wind turbines and solar panels. And you can see that they are still very high. And for example, with India, where we are currently negotiating a free trade agreement, you still have a very high applied tariff on solar. So why couldn't we also concentrate on eliminating those tariffs as a boost for green free trade? Let's move to the next slide, where we see that governments are always very inventive and creative when they do not use tariffs to use non-tariff barriers. So what does it mean? It simply means that instead of applying or on top of the tariff that you would apply, you would complicate the granting of visa for the engineers that GE would need to get its factories, wind farms, for example, up and running in a specific country. And you might have a big problem in our wind farm in India, and you would need 6 weeks to get the visa that our engineer back in Germany would barely need to fix this very important issue. Can you wait 6 months, 6 weeks before the factory is again up and running? That's an open question. You have also a discrimination around the world on public procurement. And what we call state-owned enterprise, which are basically the enterprises which are publicly owned by the states, are often awarded better access to local, regional, or national public procurement, especially when clean energy bids are at stake. Again, why? Because this is a matter of industrial policy, and those governments have identified this very sector as a strategic one. And again, you have a list here which is unfortunately not exhaustive of how creative governments around the world can be to actually bar foreign suppliers from entering into the market. Is it efficient? Does that work? And that's the subject of the next slide, which basically speaks by itself. And this is public data that you can find in the China Energy Association annual report, where you see in purple the market share of foreign suppliers in China on wind turbine energy. And the blue line being the Chinese suppliers. I don't want to comment this chart for very long, but I think it speaks by itself. What do we need? And what do we need from you, from the Commission, from our negotiators? Next slide. First thing is just a quick reminder on how it is important for us to have a level playing field as far as green energy market are concerned around the world. Why? Because this is still a risky business to invest in. A risky business, why? Because important investment costs. Buying a wind farm or setting up solar panels or getting into a gas turbine business is very costly. You have long-term returns, and you have a very unpredictable regulatory environment. So one of the things that we very need is to have clear standards around the world. Common standards. When you want to invest in smart grids, for example, you would need to have some kind of views of what the next generation standards will be, not only in China, but in Europe and in the US, and if possible, that those standards be compatible. And you would need to make business decisions to have some visibility on the market. And of course, I don't want to be too long on this one, increasing fair competition on that market is exactly what we need to have the right market signals. Next slide, please. So how to help create a world market for renewable energy? What can we do? And my point here is that what we need is basically two very important things for the business. First, zero tariffs for clean technologies around the world. And second, clear disciplines to address the very non-tariff barriers and governmental practice that I referred to earlier on. So again, what we need, concretely speaking, not only at the WTO, but in free trade and bilateral trade agreement, is zero tariff, zero local content, zero barriers to clean energy services, discipline for state-owned enterprise, and you name it. Please, next slide. But how to do that, practically speaking? Is there such thing as a well-defined universe of clean technologies? Clean technologies or green goods is a nice word, but negotiators at the WTO have been scratching their heads for years to actually define the universe of what it is about. There are two possibilities. Or you engage into a philosophical or legalistic discussion, and again, I'm not a doctor, I must apologize, so I don't feel in a strong position to engage into that. Or you simply list what you believe are the green technologies. And I would say that's the most obvious thing to do. That's the easiest one, and that's what our beloved trade negotiators are used to, because what they are used to is to negotiate lists and concessions. They have some experience about that. There are some precedent at the WTO, And we have negotiated free trade, for example, for information technologies, i.e. Informatic technologies at the time. Why not for green technologies? And the nice thing is that the EU has some experience about that. In the EU FTA with Korea that you ratified recently, there is a case where negotiators from Korea and the EU referred to a list that they jointly submitted at the WTO in 2007, and they committed bilaterally in this FTA to zero tariff for this very list of products. And that's exactly what we need, and that's the best practice to follow. Next slide. So here you have a nice picture of someone who you're familiar with, and a Commissioner de Gucht, and I want to quote him, said, "We will use both our bilateral and multilateral negotiations to include trade provisions that will help us diversify energy supplies and promote trade in sustainable energy, where barriers in third countries impede the rapid development of EU's renewable energy industry." So I guess everything is captured here. This is about EU industrial policy. This is about promoting 2020 agenda. This is about using all opportunities, be them plurilateral, multilateral, or bilateral, i.e. free trade agreements, to actually push the sustainable and clean growth agenda. And let's not be naive. What we need is to combat on a battlefield where our competitors sometimes have the backing of the national treasuries and our state-owned enterprise. So how to have fair competition with them is on actually imposing disciplines by any way we can do that. And trade bilateral agreements are a fundamental vehicle to promote these disciplines. Actually, around the world, bilateral negotiations are taking place with countries actually pursuing this green growth agenda. And I mentioned a few. New Zealand is especially active on that, Australia as well. The US, with its Trans-Pacific Initiative, is also promoting this very green growth agenda. So this is not only about Europe. This is about a global trend. Again, we need here in Europe to build upon the Korea model and not only concentrate on zeroing tariffs, but actually for the very list of goods that we have identified, get additional disciplines to discipline this state-owned enterprise and local content hurdles that we are confronted with. Last slide, we need the support not only from the Commission, but from you, the European Parliament. As a co-legislator, you have new powers. You are an essential relay for the civil society and for business, and we count on your strong voice to actually help us push this green growth industrial 2020 agenda. Thank you very much.
Merci beaucoup, Fabien Delcron, pour votre parole.
Merci.
Thank you very much. You made a very good point with a new aspect when you stressed that we not only need environmental development and standards, but that we need a free trade and an export and an exchange of technology to achieve that goal. We will focus on that in the discussion. I now give way to Dr. Reinhard Quick. He is head of the German Chemicals Association in Brussels, lawyer and professor for trade environment. In 1984, he became a trade policy advisor for the German Chemical Industries Association in Frankfurt. In 1987, he was appointed head of the legal service of the European Chemical Industry Council based in Brussels. Since October 1993, Reinhard Quick is the director of the VCI Liaison Office in Brussels, and he takes a very active role in Business Europe, the European Association of Enterprises and Businesses in the European Union. He is not only active in this Business Europe and VCI, but also he is appointed honorary professor for international economic law at the University of Saarland in Saarbrücken. where he teaches a course on trade and environment. That is a very interesting point for us. The floor is yours. Welcome to this panel.
Thank you very much, and thank you very much for the invitation and also your presentation, Herr Theurer. I would like to speak today about two issues. The first one is the WTO and the aspect of the WTO with respect to social and environmental standards. And then I would like to speak about measures to encourage the respect for social and environmental standards. Let me turn to the WTO, and I would first start with the rule-making activities of the WTO. And I think, ladies and gentlemen, you have to distinguish between environment and social here, as already indicated by Mr. Hofmeister. As far as the environment is concerned in the WTO, we do have at least the possibility to achieve rules, because we have a mandate, we have a Trade and Environment Committee, which was established in 1994, and we have a Doha mandate on environmental issues. And one of these mandates is the tariff elimination of environmental goods and services and elimination of trade barriers. And the other, and I think that is more important to the context which we are speaking here, is the question about how do we relate the WTO to multilateral environmental agreements. And what could, for example, an outcome of this situation be? I give you a suggestion. One could probably say establish dispute settlement in multilateral environmental agreements or in international social agreements, and then adopt the presumption of compatibility if you comply with the obligations of those agreements. Then one could consider that this compliance should be presumed to be compatible with your WTO obligations. I mean, just as an idea for the discussions. In the area of social, there Mr. Hofmeister already indicated that we do not have progress whatsoever in the WTO. It's quite interesting, because in the Havana Charter of 1947, we had a chapter of fair labor standards. The charter was, of course, never adopted and never became an international organization. In 1995, however, the WTO was founded. But in 1996, at the Singapore ministerial meeting, the WTO decided to defer to the ILO for all social issues. And I don't know who of you was present in Seattle at the WTO ministerial conference, and at that conference, one of the big explosions of the conference was that President Clinton announced at the Labor Union Congress that one should enforce social issues through WTO dispute settlement, and that, of course, caused a lot of hiccups. So, although we don't have much as far as social is concerned, as far in the WTO, we do have at least the possibility to negotiate on the environment. Let's turn to dispute settlement. I think we do have quite a different situation here. Because, again, I would distinguish between social and environment, because as far as environment is concerned, we have clearly seen that the WTO does not live in clinical isolation. The international treaties at least can be used to interpret the WTO. They can, of course, not apply it as such in the WTO dispute settlement. But as far as interpretations are concerned, we do have relevance for international environmental and, I would argue, also social agreements. We have seen that in the definition of like products. We have seen that in the interpretation of Article 20, the GATT exceptions. We do have problems, I think, as far as unilateral measures are concerned with respect to climate change. There are a lot of suggestions that we should adopt trade sanctions against climate sinners, and I think they do have not only merits, but they do also have quite some problems as far as WTO compatibility is concerned. Now, in the area of social, I don't think you can make a comparison with respect to the area of environment, because the enforcement is different in the WTO. Now, Thierry suggested that let's adopt unilateral trade action in order to enforce social or environmental standards. I think that can be done. But you have to have, of course, then also bear the consequences. I think it was easier to deal with unilateral environmental issues enforced through trade, because you always had a territorial approach. And at least as far as I'm concerned, in the WTO, there is still this territorial approach. You could always demonstrate that you protect your own environment as well. I'm not so sure whether the WTO would come to the same conclusion if it were, in brackets, only the so-called global commons. You don't have that in the area of social. And therefore, I'm not sure whether an aggressive unilateralism as far as social standards are concerned would be, or at least could be, considered as an abuse of the WTO system. My problem here is, why do we always ask for trade sanctions? Why don't we go to the ILO and say, adopt a dispute settlement system with sanctions? Why don't we go to the UNEP and say, adopt a dispute settlement system with sanctions? As far as the environment is concerned, you would at least, I think, alleviate the kind of taking hostage of the WTO for enforcement measures. And my question is, should the WTO be the enforcement police of social and environmental standards? It could be. I'm not saying it should not be, and we have seen that in the environment it can be, but I'm not sure whether we do want that. And I also would say, if you then lose a case, you then should also comply with what the WTO is saying. And I could imagine that we could have a lot of discussions, particularly in this House, if the EU loses a case for unilateral measures taken in order to enforce standards. Now, let me turn to the idea, what can we do in order to support compliance with environmental and social standards? And ladies and gentlemen, I'm actually quite, I found it quite interesting that the previous speakers never mentioned that we do have an international set of agreements out there in the world. We have the ILO, we have UNEP, and we have a lot of international agreements, but they lack enforcement and they lack dispute settlement. So why? I mean, that would be my suggestion. I would rather have a stricter enforcement in the areas which these institutions cover, rather than relying on an enforcement through trade and the WTO. Why is that not possible? It's probably not possible because the members of these agreements don't want it. I mean, what should stop them to say we want enforcement through the agreement in which they negotiate? And if the members don't want enforcement, but nevertheless ratify obligations, then of course you can ask the question, should we then enforce these standards through WTO dispute settlement? The other aspect would be FTA negotiations. I think there are no prerequisites on FTA negotiations with respect to environmental and social standards, other than that an FTA should lead to a liberalization of substantially all trade. I mean, that's the requirement which the GATT imposes on the FTAs. But as long as you have liberalized substantially all trade, there are no other requirements which would stop you to suggest to your trading partner what kind of issues you would like to see covered in a free trade agreement. And I think, and I support the position of the Commission that we should negotiate for WTO plus free trade agreements which go much beyond the issue of only liberalizing trade. And we have spoken about sustainability chapters. I have looked at the sustainability chapter with respect to Korea. And what is clear is that the two sides don't harmonize their standards. They respect their regulatory autonomy with respect to social and environmental standards, but they say we respect ILO and UNEP conventions. And then you have, I would argue, a kind of soft enforcement mechanism, and this soft enforcement mechanism has already been touched upon by Mr. Buttles. And there the issue is, should we have sanctions, or should we have a kind of naming and shaming or soft enforcement? In the Korea agreement, the Commission, and Mr. Hofmeister also said, no size fits all. We have this kind of soft enforcement mechanism, and I think this is a good choice. Because what can you do? I mean, just imagine suspension of the agreement. I mean, is that a real sanction? I mean, as a representative from business, I would argue we shoot ourselves in our own foot. Because we have relatively low tariffs. The FTA partners have relatively high tariffs. They have been chosen because they have potential markets. Now, if we say suspension of the agreement, we introduce the high tariffs again in the countries concerned, because they would react. I mean, we reintroduce our tariffs relatively low, and I think I would argue everything which is 5% or less, if you are competitive, you can overcome that. And therefore, if the average tariff of the European Union in industrial goods lies at 4%, I'm not sure whether suspension of the concessions or of an agreement really means anything. Now, we have fines as well. But if I understood correctly, the US has a possibility to apply fines. Mr. Buttle said this is also kind of soft enforcement, not a strict enforcement, kind of enforced financial cooperation. I mean, I don't know. I have no experience on this, and I'm not sure whether it would work. It depends on the country concerned. But certainly, don't you think that if there is a violation of an ILO convention with respect to such an agreement, a kind of naming and shaming exercise is not much more powerful with respect to how the market will react? And should we, and that includes, of course, all NGOs, not use this process, which the Commission, I've looked only at the Korea Agreement, has established in the Korea Agreement, where civil society, for me that includes business, can introduce complaints in the sense that we inform our authorities of where things go wrong. And I would like to really see, I mean, the kind of businessman or businesswoman who would not take such a thing into account. And I think that the market works much better than any fines. But I mean, that at least can be discussed. Last but not least, the GSP system. We've spoken about some autonomous measure and GSP+. There was the question, what is the relation between contractual agreements, FTA agreement, and GSP? We already have it in the existing GSP regime, that the existing GSP regime says explicitly that it prefers contractual agreements to unilateral autonomous measure, and I think I would agree. The problem which you have, of course, the more you reduce your tariffs through, for example, a successful DDA, the more you have the issue of the GSP Plus is not worth anything anymore. But I mean, that's exactly what we want. We would like to have liberal trade for all products and not only for some. Thank you very much.
Thank you very much. Some interesting thoughts there. When you're talking about market forces, I immediately think of palm oil and what is happening with that, and whether they may think that that's restrictions on the market, and whether that'll end up in WTO is an interesting one. But certainly civil society wants to know if they're using palm oil that is putting at risk some of the world's most endangered tropical forests and animals. Okay, then let's move swiftly on to our final speaker, Dr. Dalindiebo Shabalala. Have I got that right? From Maastricht University. Dr. Dalindiebo is a university lecturer in international economic law. Intellectual Property at Maastricht University. Previously, he was the managing attorney of CIEL's Geneva office and director of CIEL's Intellectual Property and Sustainable Development Project. He focused on issues at the intersection of intellectual property and climate change, human health, biodiversity, and food security, as well as addressing systematic reform of the international intellectual property system. So thank you very much. We're very interested to hear what you have to say.
Thank you very much, and it's a pleasure to be here at the Parliament again. I was here in January last year in front of the committee to talk about precisely this issue. Then we were asked to talk a little bit about the reasons why we should have environmental and social standards in free trade agreements. And I'd like to take us back a little to that because I think it matters to what we think should be the nature and scope of these provisions and chapters as we go forward and the nature and scope of enforcement. Now, we know that the EC has a long history and tradition of maintaining and expanding its relationships with those countries that were former colonies of the member states. These relationships have always been a combination of political, economic, social, and cultural ties, which have been expressed in a variety of institutions, as well as treaties and conventions. The increasingly centralized competence of the Commission on trade, accompanied by the expansion of the European Community, has meant that the EC's trading relationship with countries on the global economic periphery or those formerly on the economic periphery have expanded to include more non-traditional partners in the ambit of such agreements. In that context, and looking at the changing global power dynamic between newly industrializing countries, such as the BRIC countries, that the question of the desirability and effectiveness of broad-based agreements incorporating social, environmental, and cultural elements was brought into question. I'm glad to hear that nobody on this panel is questioning whether or not we should have them at all, which is, I think, a lovely transition to see, both within the Liberals but also within the Parliament, and maybe among the experts. So that's a good thing to know. That nobody now feels it's appropriate to question the applicability or the inclusion. What I think we need to think about now is the nature of how we integrate them, because I think this is really the second fight. I think one of the things we've seen that's driving this discussion is, in fact, four things I would point to. First is that the relationship with the global world, especially developing countries, has shifted. A move away from preferences to reciprocity, a move away from tariff lines to rules and regulations in almost every sphere of economic activity covered in these free trade agreements. The increasing centralization of trade policy in DG Trade, we know, and a growing awareness of the shift in traditional bargaining power in global markets. So Europe is in a different situation now than it has ever been. No longer has, as it used to have, the full power of preferences in its negotiations. The negotiations are now becoming more and more negotiations of equals. We no longer negotiate with just the US or Japan and EU on an equal partner basis. We now have to negotiate with South Korea, with China, with India, with Brazil on an equal basis. And this changes the dynamic entirely. We are competing for trade relationships. And it's in the context of that competition as well that I think we need to think about how we include these provisions. So, I think the elephant in the room, which is fascinating, I haven't heard too much discussion about this, is China. Right? Everybody talks about China as the key driver of concerns about this. Talk about China and its new role on the global stage, the kinds of agreements, its investments in China, in Africa, in Latin America, focusing on resource and commodity areas, and China being known for not caring, as they say, about social and environmental and cultural issues, that they provide no strings attached economic relationships. Given an alternative between the EU and China, why would a country not go with China? And I would argue that there's a category mistake here. One is that, first, we're talking in particular about the commodities and natural resources area, so on. But the other is that these are different kinds of agreements. What you have with the Chinese are contracts commodities contracts, and fundamentally between economic actors. Yes, in China you have economic actors that are state-owned enterprises, and the government stands behind the loans and provides concomitant aid, no strings attached aid. But there, the competition is not really trade competition. It's investment competition. It's FDI competition. And China provides better incentives for FDI. Now, within that context, we can have a different argument, a different discussion about the nature of China's investments, but that has very little to do with what Europe has historically done with respect to its free trade agreements. China doesn't do that. It may begin to do that, but they don't do that. And so if we're thinking about a competition for trading relationships, that's not the case. Now, as the EU gets more competence at the central level on investment, we may begin to have more of a discussion about that. But I think, at least when it comes to the inclusion of these provisions, this is an entirely different discussion. So, I would argue that the empirical data when it comes to trade agreements isn't there that countries are making a choice between having a free trade agreement with the EU or having a free trade agreement with China. They're making a choice between what sort of investment they want when it comes to an FDI. And there, the European companies can compete quite well, primarily because of the bilateral investment treaties that they have and the access that they have in terms of rules under the bilateral investment agreements. But China competes better because they provide stronger financial incentives in the contracts. Okay, so thinking about that, we know, generally speaking, that trade at the WTO and trade agreements inevitably negotiate social and environmental standards. And this is clearly acknowledged within the WTO and acknowledged within the GATT and within the TRIPS agreement and in the GATT. We know this. This is why we have GATT Article 20. It's why we have TRIPS Article 13, TRIPS Article 30, why we have TRIPS Article 40. There is a basic fundamental awareness and knowledge that in negotiating trade provisions, especially on rules and on regulations, you are negotiating the design and application and implementation of standards in environmental and social areas. We know this with the SPS agreement, we know this with the TBT agreement. So it's not as if we don't know that these are being negotiated. They are being negotiated. So the question is, how do we negotiate social and environmental standards in these agreements? Do we negotiate them implicitly through the back door by saying, okay, here are the trade standards, and if you want to do environmental and social stuff, here's a clause that will let you do it? Or do we acknowledge that specific provisions have and in fact directly implicate environmental and social issues? So for example, Article 31 on compulsory licenses in the TRIPS agreement, no, we have a clear exception in there for public health because it was understood, for example, that this is a particular issue that needs to be addressed, and therefore we put an exception in here to address public health emergencies specifically. And so I would argue that what we see now, this whole concept of sustainability chapters or environmental chapters, separate from the so-called trade chapter, where you negotiate SPS and TBT and TRIPS enforcement, I think is a disingenuous and I think not useful division. And it's not useful because precisely with respect to the dispute settlement. Because what you do is you then make the standard and the rule subject to dispute settlement, but the thing that it affects not subject to dispute settlement. And so to have a separate chapter is to deliberately create a situation where there are weaker environmental, and it's not necessary. It's not necessary. As an IP specialist, I have many complaints about the WTO IP system, but I will argue that one of the things it was very good at was integrating the concerns regarding competition law in Article 40, in Article 30 in Article 31 regarding public health and emergencies into the trade aspect themselves, and therefore making them subject to dispute settlement and creating certainty about when they would be applied, the standard that would be applied, and the proper scope that would be applied. So when you look at why we have these provisions or these chapters in trade agreements, because we understood they were being negotiated, then doing so and negotiating them in separate chapters, I think, totally misses the point of why we are trying to address them in the agreement in the first place. So, what do we do then? Well, I'll point to a couple of areas where it is, I think, clearest that we can't have a separate chapter. It has to be integrated in the trade chapter. So, intellectual property, border enforcement, areas related to public health, for example. We know that has to be integrated in the chapter. And, for example, you take the Doha Declaration on Public Health and integrate those provisions directly in the chapter and not externally in some other chapter. On government procurement, the freedom to regulate, especially with areas such as, for example, in South Africa, to redress historical economic injustices. The ability to do that sort of thing has to be integrated in the chapter and not elsewhere as a right or freedom to regulate. Because if that's not subject to certainty and regulation under the dispute settlement element, there you are put in a position where you cannot really create the kind of certainty and freedom you want in the agreement. The biggest area where you really will need to go through every single trade provision and ensure that it will comply and meet the standard you want is in the area of climate change. The biggest economic challenge we have, requiring changes along every part of the value chain in production and consumption. How do we address this? Do we have a separate trade and environment chapter that deals with goods that are environment? I think that's both a category mistake and also will not accomplish the goal that we want. You can identify a very small group of non-dual use products, but otherwise you're talking about products that are things like steel, cement, consumption like light bulbs, things that have multiple uses beyond the environment, and how do you control their particular use and their particular tariff lines and the rules regarding regulating energy efficiency and labeling without including those issues in the main trade agreement and not in some non-enforceable chapter. So climate change, I think, presents both the clearest challenge and the clearest opportunity for properly integrating these issues into the so-called separate trade chapter. So, closing off, I think my argument, therefore, is that the problem for the EC is not the existence of social and environmental chapters in their trade agreements, but the failure to properly integrate them into the negotiations in the trade chapters. Now, how would I suggest we think about this as a lawyer? Right? Talk about this as a lawyer. Well, first of all, I think a fundamental guiding principle for how you do this integration is that there is a fundamental obligation not to defeat or contradict the aims and purposes of existing and signed treaties. That has to be integrated into every element of a so-called trade chapter. Impact assessments are key here to allow you to guide how you do this. Doing impact assessments during or after the fact is pointless, as we see with the trade impact assessments that the Commission conducts and then pays no attention to. So you really actually need to integrate these into your trade provisions. The other thing is that many international treaties have trade obligations in them, other international treaties. So, for example, the Convention on Biological Diversity has obligations on technology transfer. United Nations Framework Convention in Article 4.1c and Article 4.5 has obligations on technology transfer, and these can be integrated into the trade chapter as part of the structure of how you do of the GATS and the GATT and of GATS-like and TRIPS-like provisions. With respect to dispute settlement, you need to make these clauses subject to dispute settlement in the same way as other portions of the treaty. Or, at the very least, make a reference that under that dispute settlement, applicable law, this is where you have a difference between our concept of what is your jurisdiction, based on the four corners of the treaty, and the applicable law you can apply to the dispute between the parties. There you can say that the applicable law here must include the other international treaties on the particular issue under specific dispute that the parties are both party to. Now, we have jurisprudence at the WTO that has somewhat contradictory conclusions with respect to whether you need to do that. But with respect to the FTAs, that's not an issue you need to worry about. You can set your rules on applicable law with respect to disputes on the FTA yourself. And so even if you don't make them subject, environmental and social clauses subject of dispute settlement, you can make the applicable law to which those respond both applicable in the dispute and also as a guide to interpretation in the dispute. And on that note, my 15 minutes up, and I look forward to questions and comments. Thank you.
Thank you very much. A lot there in a short time, but some very interesting ones. Yes, and the elephant that seems to go round with everybody in this building is China. It is ever present, and whatever committee we're on, there's some element that we're all looking over our shoulder at what is happening next in China. So let's go to some questions then. I don't know, Grégoire, did you have some questions that you wanted to add? No? You didn't want to?
Actually, I already had a chance to interact, but I can make two precisions but if someone wants to take the floor before, that's really fine with me.
Let's see if the audience then has this question over here. Could you introduce yourself to?
Jens Alsbjerg, I represent Vestas Wind System, which is a supplier of wind turbines. We're a global company with a manufacturing footprint all over the world, and therefore we're very much engaged in the market access discussions, and we see exactly the same challenges that my colleague Fabien explained brilliantly before. Market access is extremely crucial to us in our efforts to combat climate change and expand green technologies across the globe. We very much appreciate the efforts done by the Commission to boost free trade agreements all over the world, and also to play a proactive and positive role in ongoing WTO negotiations. Therefore, also perhaps a word of caution to you as parliamentarians, that if we have FTAs with a lot of human rights clauses, green clauses or the like, it would be perhaps even more difficult to reach agreements in FTAs. I appreciate very much the approach proposed by Mr. Hofmeister and others to have a constructive dialogue rather than sanctions. When we negotiate, or when the Commission negotiates FTAs with developing countries, it's difficult. Also for the reasons of dual use, single use. In other words, that a lot of the developing countries seem to think that products, perhaps predominantly being exported by developed countries, are in reality not green goods, but are dual use products. The concessions are therefore not very welcomed by the developed countries. In that situation, it would be increasingly difficult also if you had a broad range of other clauses in terms of human rights that you want to include. By the way, we do think that we have a good list of single-use products that are only environmentally valid, wind blades being one of them, obviously. There's a whole range of products that are really only single-use, but we could perhaps come back to that. So those were my remarks. Thank you.
Thank you. Does the panel have anything they want to return on that? I mean, before, can I just add? I can understand your concerns about human rights and labour standards. However, what I am keen to include in our free trade agreements is a similar standard to the ones that we expect our companies to trade on in the EU. There are a lot of things that we tie our companies that on employment rights and health and safety. You know, the basic rights that we expect our companies to abide by. And if we're saying to our European companies that if you are trading in a third country, you can lower those standards, but the profits will come back here again. I think that's disingenuous, really. And I think that's where we need to be watching our trade agreements. So I'd be interested to hear what our panelists have to say.
I think, I mean, I'm not sure whether I agree 100% with you, Madam Chair. But I think what should be pointed out is a free trade agreement, for me or for us, goes much beyond free trade and should include what is considered as WTO plus, or name it as you want it. I don't have a real problem with that, because as long as you liberalize trade, you are free, of course, to add provisions in this agreement which both sides agree to. And that can also be strict social or environmental or whatever regulations you would like to achieve. The problem I have with the idea of environmental goods is that I find it difficult to define them, because even your wind blade is made out of goods. And are these goods environmental? As a representative of the chemical industry, I would argue you cannot produce your wind blade without our products. So my product should be considered environmental as well. You see, and therefore, before we go into a discussion of what is a good good and what is a bad good, I would rather have liberalization of trade in goods altogether, and then added to which you add the close clauses which you deem fit for such an agreement, and which of course the other side accepts as well. What I certainly would challenge is that you don't liberalize in order to introduce environmental and social chapters.
I think just to address the two issues, the difficulty and the list, I think one can imagine relatively interesting lists, but when you do sort of proper environmental integrity assessments, either you do life cycle analyses, others, you run into this precise problem. And so, I mean, we've seen this with the CDM, even just doing sort of additionality analyses in projects or things like that. It becomes very difficult to do a real objective analysis. And so really what you're left with is a bargaining process. We're happy to have it be a bargaining process, but then there has to be a reciprocity to that bargaining. And this is where you run into the problem, which leads me to my second point about what it is that environmental, social, and cultural chapters are about. One of the impressions that, frankly, and I think we have to be blunt about this, that Europeans tend to give, and Europe tends to give about these chapters is they are about demanding standards and rules from their partners. And I think we need to shift to say that this is actually about implementation of existing obligations, not just from our partners, but on our part as well. So, for example, in each of these agreements, for example, not only is it about minimum standards, it's about assistance in meeting those standards. It's about technology transfer. It's about all these other things. That also needs to be on the table. And if you look at each and every single one of our agreements, of the Europe's agreements, we don't actually have that other side of the equation when we put in environmental, social, and cultural standards. Right? We talk about rules and minimum standards, but when it comes to actually, and we want to make those subject to some form of monitoring, etc. But when it comes to actually the other part of that, which is doing the technology transfer, doing the financial assistance, that's not monitored. That's not subject to dispute settlement or any other process. And so there has to be, if there's going to be bargaining, there has to be proper bargaining across the board, not just in a trade chapter, but in the other chapters as well. There has to be an offer on the table. It's not just trade against environmental social standards, but within the environmental social standards, there has to be an exchange as well. And we see this. When they sign the UNFCCC, there's an internal bargain to that agreement that needs to be imported. The internal bargain to all these agreements that can be imported into the negotiations. And then finally, the issue about the difficulty of convincing countries to negotiate. I find that also a bit of a disingenuous argument, because it turns out other countries and other parties object deeply to having, say, provisions on border enforcement on intellectual property in the agreements. And yet the EU finds somewhere both the political will and the energy to insist this is a red line. So if there is energy and capacity to insist on an area where countries have clearly expressed a refusal to try to address that issue. In India, we have the whole entire IP chapter is still under debate. We know India will give in on this because the EU will not have the agreement without it. And so we make a point that this is what we must have. So then, what else are we willing to put on the line for this? And I think this is one of the things where it's not that it's difficult, it's that we prioritize one area over another. And then the question comes to us as the Parliament, people in the Parliament, how do you ensure that these other areas are just as much of a priority?
Thank you. Yes, do come back.
Yes, maybe just 3 points as a quick reaction. The first one on the definition of what is an environmental good and what is not an environmental good. I would say that's an interesting, quasi-philosophical, but quite abstract question. And I would say that's a question that we already solved. In 2007, we agreed with a bunch of WTO members on a clear list that defines the universe. And we have successfully used that list to zero tariffs on those products in the EU-Korea Free Trade Agreement. So let's be concrete. If you agree that there is an urgent problem, let's not give our competitors the luxury to evade ourselves into endless debate, and let's concentrate on this list. The second point I just wanted to make is that this is, of course, a matter of definition, of negotiations, and this is a living list, meaning that, like the WTO negotiators, when they negotiated the agreement on information technology in the late 90s, they provided mechanism for regularly reviewing the list, updating the list, including new products. And in an environmental goods list, you can have chemicals products, of course. You need chemical products for green buildings. This could be, integrated on a regular basis, provided that you would match certain criteria and standards. And the last thing I just wanted to react upon is this notion that, what would we negotiate with the EU, why not with China, and we are in a more complex world than before. That's all true. But let's be confident. We are the first customer market in the world, and we are the less risky area in the world in terms of foreign direct investment. So we have a high value for the Brazilians, for the Indians, for the Chinese, and the other partners that are actually queuing to negotiate with us. And this single market is a unique asset that we have to help us promote our non-trade and value-related issues, environment and human rights being amongst them. Thank you.
Thank you. I find that very interesting, but a bit one way, because I think if you're talking about trade, it's two way, and I've been working in Cameroon just recently on tropical timber. Now, is that an environmental good or is it an environmental bad? And it depends how it's harvested and how it's controlled and the rest of it. There is a high demand for tropical timber in the EU, and yet we know that the way it's being harvested is unsustainable. And so what we're trying to do as the European Union with the voluntary partnership agreement is regulate that trade and to ensure that it is harvested sustainably. It's again us making demands on a third country, and in a rather paternalistic way, it's, you know, we sort of think it's in their best interest, because then if it's harvested sustainably, they've got a long-term trade with us and with whoever else. So yes, it is very difficult, the definition and including that. The eaters in the ACP countries are something that the European Union has tried to sell to them and get them to sign up, and they're singularly failing because they're just not. They don't see that as being fair agreements, and they're stalling all over the place. So I think there's so far one signed and one initialed. So and that's some years that they've been progressing down that route. Right, any other questions? I'm sure we have some more to our panel. Yes, did you want to come back?
Yeah, thank you. I would like to come back very quickly on two issues on which I think the European Parliament should not step back. The first is the automatic inclusion of human rights clauses, and the second is the human rights impact assessment. We have been told by Mr. Hofmeister that the EU partners were reluctant in agreeing on human rights clauses. I don't know if this is supposed to be a scoop. Of course there are, and there will be partners reluctant to the inclusion of a human rights clauses. But the best way to limit the political weight of this inclusion in the negotiations is to make it automatic, is to make it a principle, it's to make it non-negotiable. And on the contrary, by setting precedents, such as with Korea or India, the European Commission is itself feeding the future reluctance of next partners in negotiations. So I think that at least the European Parliament should be very clear about the automatic inclusion of this human rights clause in all EU third countries agreement. This is a principle that was established in '95 with Chris Pattern, and all agreements since '95, except those 2 or 3 first ones, all EU third countries agreements have included human rights clauses. So it's a very dangerous precedent, and the European Parliament should react to us very strongly on this. The second issue is on the human rights impact assessment. It's not a question of policy, of political option. It's a question of international obligation. The UN High Commissioner for Human Rights, the UN Committee on Economic, Social and Cultural Rights have clearly stated that the UN state parties should take steps to ensure that FTAs and BITs, the bilateral investment treaties, do not adversely impact on human rights. What we are asking is just an instrument to measure the potential negative or positive impact of those trade agreements. This will not only increase the compliance of the EU with its international obligations, but it can also improve the content of the negotiations, improve the content of the trade agreement, improve the parallel measures or the compensation measures that both parties can take. So that's really, again, a question of international obligation and a question of precaution. This will not prejudge of what will be the agreement. It's not a judgment on the human rights situation in the third country. It's just an objective assessment of the positive and negative impact. And I think this recommendation was included in the SAIFI report of November 2010. And I'm very surprised again to see the reluctance of DG Trade to move forward on this. So we perfectly know they are very opposed to the idea of having a specific human rights impact assessment, but we have already said that we would agree with a compromise to include at least a formal human rights chapter in the existing sustainable impact assessment. I think that would be the minimal measure, to have a formal human rights chapter with specific human rights indicators, and then we could discuss the modalities of this implementation on the independence, etc. Thank you very much.
Yes, any other questions? Yes, there's 2 here. Let's take you first and then come to...
Thank you. My name is Luis Portero. I'm representing DG Trade. So I just wanted to react to some of the things that have been said, and quite recently by the speaker from the International Federation of Human Rights. First of all, on the issue of human rights clauses, I mean, we're coming back to that, but in a nutshell, the situation in the Commission practice and the Council practice, for that matter, is that whenever you have a framework agreement, whenever you have a general agreement, you would have a human rights clause that would apply to the entirety of the relations of the European Union with that partner country, including trade relations. A subsequent trade agreement would just have a link back to that clause, making it clear that it is also applicable in that context. And that is the situation in Korea. So we really cannot see a reason for describing the Korea agreement as significantly different from what has been said, has been done in other occasions. That is, of course, the general line. The situation with Colombia, we have seen the clause on the screen, is a bit different because this general framework agreement is not yet in force with Colombia. So therefore, you have a clause in the FTA itself. Now, whether or not it is automatic or it can be changed depending on the partner we are talking to. Well, this is obviously I take the point about the automaticity. However, it's a point of political assessment for the political institutions, the European Commission, the Council, and the European Parliament, of course, because ultimately one also needs to ask himself the question whether you would bring about improvements, social improvements, economic improvements, improvements for our companies, and also improvements for human rights without engaging at all, if you are inflexible. So obviously abstention from the debate may not be, as a matter of fact, the best course of action in all situations. And on the issue of human rights impact assessments, I heard that DigiTrade is reluctant on this. Well, that's not entirely fair, I would say, because the issue of how trade liberalization would impact positively or negatively on human rights is really at the core of the system of sustainability impact assessments. There is clearly a direct link between economic and social human rights and the economic conditions prevailing in the relations between two countries and trade conditions. Now, whether this comes out sufficiently clearly from the impact assessments as they are undertaken currently, that's a different question, and I'm sure, and we are sure in DigiTrade, that improvements can be made in the practice, so that this comes out more clearly and perhaps it is looked at in more detail. You have social rights, you have economic rights, the right to fair conditions of work, the rights related to access to sanitation, to water, etc. These may be or not related to certain trade issues. Well, okay, let's look at them as such. Obviously, the link between right to life or freedom of religion and trade concessions is a more tenuous one, and that's the least one could say. So that is not that much a matter of assessment in terms of analytical tools or quantification. It's more a matter of eventually a political assessment in the context of the essential elements clause that Mr. Batt has referred to. So that's what I would like to say in reaction to those points. Well, of course, I mean, all these are matters for debate. I mean, we do not deny and we do not want to refrain from debating these issues. Well, I think I will stop there.
Thank you. Mr. Bartels, Dr. Bartels wanted to come back.
Thanks. Yeah, just on these 2 points. Yes, I take your point about framework agreements, but that doesn't explain India, which is not a framework agreement. And, I mean, just on the law, it just doesn't work. I mean, it does work with Cotonou. It doesn't work with India. That's just not what the clause says. And the ECJ said the same thing. I mean, there's no appropriate measures in there. So all you can do is suspend that agreement. I mean, I'd love to have a legal debate on this, but for me it's really very clear-cut. Even more problematic, and we're not, I suppose, allowed to talk about this, except that we all know that the draft text has been leaked. There's a Canada agreement where on the draft text there is simply no human rights clause, and of course there's no framework agreement. So if these are indications of a new policy, it's a concern. If it's not an indication of a new policy, and if the legal argument pans out differently, of course, then it's not, of course, a concern. So that's at the level I think it should be. On these human rights impact assessment, well, you only need to look at the India Sustainability Impact Assessment to see that the word human rights basically doesn't appear there. Now, of course, liberalization has an effect on people, and one looks at that in terms of social and economic rights by implication, no? And that's what the economists look at. But a proper human rights impact assessment would assess the effects as assessed by the economists against legal standards of human rights protection. And the sustainability impact assessment, which, I mean, I'm just using that example, I don't think there were any lawyers involved, certainly no human rights lawyers. They just didn't do that job. Now, it may be that you can say with some confidence there will be 1.6% growth in Indian wages in the long term. I'm not quite sure how they could say that, but they did. This is simply not addressing the real issue if you are concerned about human rights.
Gentleman on the end there.
Hi, I'm Yorgos Saltinzis from the International Trade Union Confederation. As the issue of the sustainability impact assessments came up, I'd like to bring up an issue. As far as I understand, it's ongoing. It's under an ongoing process of reviewing the SIAs. What we would like to see is a better mechanism to take into account the results of the sustainability impact assessments into the creation of the European trade policy, maybe even at the level of the mandate. The way it's happening right now and the timing is that actually the SIA is being produced while, or even after sometimes, the negotiations are over. So whatever it says in there is not really taken into account. An example, an example on this would be Colombia and Peru. At some point in the SIA finds that ratifying and putting this trade agreement into force would expand certain industries in Colombia and in Peru, and that is mines, it's the palm oil, it's usually commodities, it's mostly commodities actually. So in Colombia there is an internal conflict, even if the government does not really want to say that and admit that. There are some organizations that are speaking even about 400,000 to 500,000 people being displaced or are displaced. However, I'd say the figures that are more credible would be around 200,000, 300,000. So these people are usually indigenous people who live up in the forests. Because of the expansion of a big mine, for example, water needs to be diverted towards the mine, so they take a whole river or anything. It's their natural capital on which they really depend. So losing their livelihoods, assets, their entitlements, as Amartya Sen would say, these people are internally displaced, either because of they need to go somewhere else to look for ways of making a life, or they're displaced with force because they are living in an area which is forest, which is going to be deforested and then turned into monocultivations and stuff. So all this is seen in the SIA. And the SIA also says that the trade between EU and Colombia and Peru is minimal. It's going to stay minimal. It assesses, it predicts that in 2018 it's still going to be below 0.3. I don't really remember the figure. And I'm really wondering why the EU is really ratifying or even, just negotiating this type of agreement with this country. There is a global champion in violations of human rights, maybe. In terms of trade unionists, I could tell you we are having the last 30 years at least 100, 150 unionists shot dead with a 95, 96% of impunity. It kind of looks systematic to me. And the US, who are not that famous for the human rights, let's say, agenda, while the EU tries to, promote themselves as the champions of the human rights protection and many other things. The US refused, actually, on these grounds, the US Congress, to ratify or sign any this type of agreement, while the EU did not. Another example comes from India. The SIA on India fails to take into account the 96% of the Indian population who are actually working in the informal economy. So SIAs should really be rethought and be constructed in a way so that the negotiators have taken the results into account before they go to negotiate, if we want to be honest about what we are doing in here. And because we are also talking about cohesion, well, I found really enlightening the presentation by Mr. Delcros. However, to be honest, I didn't really understand his role in here because we're talking about environmental standards. However, he spoke on another very, very important issue, how to get environmental technology and goods to other countries so that we save altogether the environment, right? But because we're talking about cohesion in policies, I've been recently in the LDC's conference of the UN in Istanbul, but many other also conferences or organizations that take decisions on how to sustain development or promote development on their own means of these developing countries, either LDCs or not. The approach Mr. Delcros took, I think, is not really helping. Might be helping the environment, but it's not really helping other issues of sustainability, because sustainability, we don't find it only environmental, we also find it social. And in the way Mr. Delcros proposes to aggressively open up trade, to eliminate even local content requirements which might have an impact in local development, it seems to me that all it's going to be done in the end is to reproduce the Western, let's put it that way, American, European, the developed ones, dominance over the technologies that are taking the world a step further, even if it's on environment or on any other issue. Thank you.
Thank you. Does any of the panel members want to come back on to respond to that?
Yes, thank you very much. Why I've been invited? Maybe I'm not the best person to respond to that question. I thought I tried to explain that promoting environment protection is about standards, but it is also about business, green jobs, and competing on a fair basis. Otherwise, what you risk to have is balkanized type of markets where each country would do its own sustainable policy based on its own industrial policy and its own technology, which is a suboptimal solution if what you really care is about green growth. Thank you.
Dr. Quick.
Thank you. I think you raised an important question, and that is, with whom should we negotiate free trade agreements? And I think that discussion should be or can be seen as open. I mean, I guess I have different views than maybe you on this issue, but I think it is important because the sustainability impact assessment evaluation, which you described, would probably happen with or without the free trade agreement. And then, of course, the question is, what is better? Do we have more leverage in the sense of environmental and social issues with an agreement or without one? And I think that question needs to be answered. I personally think we should conclude a free trade agreement with the United States and not with Colombia.
So why are we not doing so?
because there's no political will.
That is an interesting one to throw in. The leverage that you speak of course, whatever we put into those agreements, unless they're enforceable, is it worth putting them in, whoever we're negotiating with?
I wanted to say one more comment. Local content requirements normally are incompatible with the WTO law. Sorry to say.
Enforcement is, of course, key to making sure that your standards are maintained in those circumstances when the parties don't voluntarily do that because they think it's a good idea, in which case you'd wonder why they would need to write these standards in an agreement in the first place. So it is part of the logic of law that if it's going to be there, there is also going to be a remedy. In fact, there's even a Latin maxim to this effect, no right without a remedy. Although, of course, as an international lawyer, I'm somewhat skeptical of this. On the other hand, practice shows even in those examples that I referred to before, where there are remedies, the US examples and so on, there has been very little enforcement. It actually has not been a great success. So it's a mechanism that has not actually led to much result, which means that even if one were to argue for enforcement based on that precedent, to the extent it's applicable, one shouldn't assume that everything, therefore, is going to be actually enforced.
Thank you. We have another question over here.
It's not a question. Carlos Vanderloo from the Mission of Canada. Thank you, Dr. Bartels, for profiling our negotiations. Just a quick comment. In fact, Canada and the EU do have a political framework agreement. It was actually the first ever signed by the EEC at that point with a developed nation back in 1976. Now, the Commission, as part of negotiations, has expressed their interest in updating the political agreement to reflect changes in the last 30-odd years. And we're in the initial steps of exchanging views on what that update could look like. So it's in train.
Thank you for that clarification. Yes, Tracy.
Just very shortly. Well, you already got a partial reply, and just to say that, of course, a leaked text cannot be a reflection of a policy change. And besides, the Commission is not empowered to enact those policy changes because the Council and the Parliament have to, of course, look at whatever is negotiated. So that's one thing. And the second thing on enforcement, we totally agree that this is a legitimate debate, and it's a serious one to be had. But it's a debate that has to be conducted in full knowledge of the several elements that are in play. Let me just give you an example. Let's say a multilateral environmental agreement on persistent organic pollutants, on prior informed consent. Do they have enforcement as the one you would think of in terms of fines, trade sanctions, etc.? Well, no. Are they deprived of value because of that fact? No. So this is one element. It doesn't mean that we need to come to the same conclusion in the trade context, but just one element to be taken into account. And then what you said about the North American practice is also important. There would be a lot to say about the systems that have developed in North America, but have they ever been used? Well, the answer is no. Are there reasons for that? Yes. But that would be a very long discussion.
Well, thank you very much. Oh, sorry, did you want to come back? Yeah.
I hope we don't lose the point that was made about the SIAs. I think it's important to really take a look, and I'd really be happy to hear from DG Trade about what they think the usefulness and the potential for reforming the structure and the framework of the SIAs so that they actually serve, I think, their intended purpose in terms of design and integration into things. I think these are fundamental to ensuring that we do get the environmental and social standards we want in the agreements, and ensuring that DG Trade gets what it needs, which is that not get overloaded, only gets what is necessary to achieve the ends. And the SIAs are a great way of doing so. And everybody else can see that, yes, within this context, these are the provisions we need, and we don't need all this other material that maybe might be superfluous or unnecessary in this particular thing. But if without a proper integration of those, I think we end up with throwing darts at the wall and hoping everything sticks, and then hoping to get some form of enforcement across the board. So I would really be interested to hear more about what they think about the role of the SIAs and where those might go, and maybe the Parliament's role in receiving, reviewing, and responding to those in some fashion might be we'd be interested to see what that might be as well.
Thank you very much. Right, if we have no more questions, I'm going to hand over now to my colleague, Michael Thurer, to give some concluding remarks from the parliamentarians. Thank you.
Yeah, sorry for missing a probably very interesting part of the discussion, but there was an obligation on another committee. If we look on what we heard from our panelists and what I got by Catherine, now what was discussed, I think we have to mention, or we can fix that environmental, social and human rights issues can be included in free trade agreements and should be included in free trade agreements. Perhaps we have a different approach comparing what Frank Hofmeister said to what Mr. Bartels said. There are other free trade agreements, especially signed by the United States of America, which have perhaps further regulations or further standards included in the agreements, but there is the great question of practicability and effectiveness. How can they be imposed? So the discussion in the European Parliament certainly should now focus on what is a workable system. Just to write something into a free trade agreement which is not applied, which is not working later, makes no sense. So I took from this discussion the statement of Frank Hofmeister when he said the European Commission wants to establish a platform on which it can be talked with the governments of other countries, so that the European Union takes a kind of soft power way to push forward human rights issues, the inclusion of civic society and social environmental standards. That will be, and that has to be discussed further on in the committee. If we look on the US Congress, not only my colleague Kaspari, but others, we call for a free trade agreement with the United States. So we would be open for that, but that is another question. I think a very important statement was by Monsieur Decroix, because you mentioned that free trade is still a goal we should achieve, not only to save our jobs and our wealth, but also to push forward environmental and social development in all parts of the world. So we can only solve environmental problems if there is technology available. We have that in other questions, and I think Mr. Jalavala mentioned that we have to provide an access for the people in other parts of the world to modern technology, to modern medicine, and we should open our goods, the exchange of goods, especially for environmental technology. So if there is a world trade that is from the first sight positive, and if we look in the financial and economic crisis, we had a drop down of the world trade by 19%, and if we would not have had the World Trade Organizations, other states would have pushed up the tariffs far more than they did. And if you look in the economic history, we realize that in the financial and economic crisis, the countries behaved like in the early 30s. when they were pushing up the tariffs, and only the World Trade Organization prevented us from getting back into that race in pushing up tariffs. So we should have in mind that that trade can help to develop wealth and to create and to save jobs. From that point of view, I think it is worth to focus in further discussions in the committee on the impact assessment, which was raised by the human rights organizations and other members here in the discussion. How can this be controlled? I think an impact assessment can be a very useful instrument to monitor the developments. We should have that. It was mentioned the prison labor. There was a strong movement in European Parliament towards China. We would like to have a ban on products from prison labor. But then it was mentioned by panelists that we need a kind of control system. How can we trace back the goods? Where are they coming from? In the first way, it sounds very easy, and we just discussed it, and Catherine Berder tabled a report on that. This was CSR in international trade, how we can trace back our products and how we can have a kind of certificate on it. That might be a very good idea, but we should all have in mind that there will be, if we include that in free trade agreements, reciprocity. It will be not only then the right of the European Union and our monitors to look into the production plants, perhaps in Malaysia or in India or in China, to look whether there are social or environmental standards obeyed. But if we have that in a bilateral free trade agreement, there will be a reciprocity, and then we have to open our plants for people monitoring from other countries. And as we have a huge question on whether these visits could be used to look into our technology, we should think about that very closely. And if you mention our technological advantage, we already face in some parts a huge competition, and perhaps there will be not such an advantage in future anymore. So we also have to have in mind the competition questions. From that point of view, let me conclude with a great thank for all panelists taking part in it. There will be a documentation by the ALDE group. We will bring that to the group because Catherine Berder and me, we raised the question because we sometimes have the discussion whether we should give our approval to a free trade agreement. We discussed it with South Korea. In South Korea, the parliament really took the new role and we pushed things to include the concerns of stakeholders here in the European Union, the trade unions, also the Business Europe and others, with the safeguard clauses. And I think we did a quite good job to improve the agreement with a good safeguard clause, which could be a blueprint for the next trade agreements. But we still have great discussions, for instance, on the Colombian agreement, and other agreements like with India are now coming up. And therefore it was a really good thing to have this hearing, this seminar here in this morning, to put the questions away from one agreement with one country to a more general level, because I think we should establish guidelines. And from that point of view, I think for our parliamentary work, we can take a lot of points to discuss with the Commission, and we hope that we can introduce workable environmental and social and human rights standards in our free trade agreements. And beyond that, we should all think about how we can control and make these agreements after that effective. And I would like to suggest our ALDE group that we investigate more closely what the United States include in their free trade agreements, and we should discuss with the colleagues from the United States why they don't put it into work after they included it in the free trade agreements. Perhaps that will be the discussion for a next hearing. Thank you very much for participating here, and I think we will have a really good basement for our further work in the Parliament.
Well, thank you very much, Michael. Just to add to that, the union is based on values, and they run through all that we do here in the Parliament as well as in the other institutions, and that is really why we're here and working so hard. And if we don't reflect those into our external policies, and it is good to hear that we have shifted from discussing whether they should be in there to being in there, and I think now we need to be fine-tuning them to make sure that specific types of industries are included, especially environmental, because as we have also heard, that the trade is going to happen, and if we don't regulate it, then we are more leaving some of these countries perhaps more at risk than actually regulating our trade and our companies that do the trade. I think one of the big issues is how Parliament is going to take its role on. We are keen to play our full part, not only in the drawing up of the agreements, but also that enforcement role. My biggest concern is the environment, of course, and how on earth we're going to regulate the Europeans' insatiable consumption of the rest of the planet, of course, is another topic that maybe we'll come back for. But on the topic of consumption, I would just remind you that there is some sandwich lunch served outside, so go and consume there. And thank you again to all our speakers, and thank you to the guests who've been here to listen to the debate. Thank you.